Well, let's bring in Bruce DelValle, who is a litigator and constitutional law expert. He joins us now live from Maryland. Bruce, great to have you with us. So we heard a little bit from John there that the executive order doesn't change the law. So does the president's executive order have any real power here when the courts have previously upheld the platform's immunity on this?
Right now, not really. I think what the executive order does is this brings this issue to a head. And I think John is correct, and you're correct, that this is more of a political act. The very act of the executive order is the importance in and of itself. Section 230 is what we're talking about here, and that was enacted by Congress back in 1996 in response to fears that the internet would die while still an infant because it would get sued for defamation and there'd be various lawsuits. So what we're talking about here is a tort immunity, what's called a tort immunity. It's immunity from damages, causes of actions. That's really all it is. And it's grown into this thing from protecting an infant to now the largest, most valuable companies in America, perhaps even in the world, are these tech companies that are now getting protected. And a lot of critics of 230 believe that it should be repealed. It really is not fair. If you say something or I say something on your program, on a broadcast, and it's defamatory, you could be responsible. The New York Times is responsible for the content. They get sued all the time for defamation. But what this law has done since 1996 is immunizes the internet. Internet service providers and platforms can't be sued. They are absolutely free and immune from any suits. And the reason why is Congress decided to classify them not as publishers of information, but as distributors. And if you think about it, it makes sense. If you're a publisher, you can edit your content and you put out your book, your magazine, your newspaper. If you own a newsstand or a library, you would have to read every single book in the library or every single newspaper every morning in the newsstand to assure yourself that there's no defamatory comments or content that you could get sued for. So initially, the internet was considered distributors only. That's just not true anymore. It simply is not true.
Right. Why are we seeing, Bruce, two different approaches here from Facebook and Twitter? In other words, why is it in Facebook CEO Mark Zuckerberg's interest to keep it? He seems to be leaving the issue alone and saying this isn't for platforms to police.
He's very smart. He's getting out in front of this. I was going to mention that to you. He understands where this law comes from and what this law does. This law immunizes him. He has a multi-billion, maybe trillion-dollar company that is immune from lawsuits, the bane of the corporate existence in the United States. He can't be sued as long as 230 is there. If the people that benefit from 230, these giant megalith companies, are seen as arbiters of the truth, people that decide what gets said, what doesn't get said, what gets published and doesn't get published, he suffers along with Twitter, Google, and the other online services. Mark Zuckerberg is smart enough to know that this is the golden calf and he doesn't want it to be slaughtered. He's out in front of it. And that is as good of a reason as anyone needs to see the inequities in this Section 230.
So where do you draw the line, Bruce, the legal line at when someone is a publisher versus when they're a platform? Because you look at Twitter, which is absolutely giant. I mean, look at even the number of things that the president tweets. There is so much content on there. They've since gone back and added a fact check label to the Chinese Foreign Ministry spokesperson's what many would be considered to be a conspiracy theory on the United States dropping the virus in the center of Wuhan. How can you it's such a huge platform. As you mentioned, these social media companies have gone from infants to giants.
Well, the line is, I think you have to look at where it came from. In that original case I told you about, the judge in New York, it was Oakmont versus Prodigy, which inspired this law. The judge in the New York Supreme Court said, now hold on a minute. You have exercised editorial discretion. You have done more than just simply put up a bulletin board. You have made decisions. That makes you a publisher. In this context, that's very hard to argue with. If Twitter is making editorial commentary or saying your tweets can't be on, or Facebook says, no, we're not going to let you appear because we don't like what you're saying, and there's a great deal of data out there that does not dispute this. As a matter of fact, there is data that shows that if a person that identifies himself as African American speaks in a strident fashion, they are more likely by a multiple of times to be banned, barred, or removed from Twitter than someone that says the exact same things that identifies as being Caucasian. So this is not just an anti-Trump thing. This is a thing where they have all the power. They are what they are publishers, and I think it's time to recognize that. I think, however, this executive order isn't the right way to do it. The United States Congress has to repeal or change the law. This executive order does not have the force and effect of law because it doesn't have in my mind, doesn't have a firm constitutional basis. Good idea, wrong way to do it.
Right.
So when the Department of Justice steps in and says they're going to start looking at complaints from people, which of course they're going to be inundated by thousands of complaints, I don't know what that means in terms of real world lawsuits being filed. The other thing that I find incredibly interesting is the FCC, the Federal Communications Commission, has not been asked under this executive order to participate. And that's very odd because the FCC has a rule, a regulation that says that if you violate anything the FCC thinks you shouldn't violate, there's a daily penalty that is very substantial. To my knowledge, the Federal Trade Commission,
you bring up
who the
so
Trump
many good points. I could honestly have this conversation with you for another 15 minutes. You bring up so many good points, and we really appreciate you touching on all of those legal aspects of why this is such a complicated issue. But we've got to pivot to some other news. Bruce DelValle, thanks so much for being with us.